Okay, excellent. Well, welcome everybody. We're super excited to have our partners from Fisher Phillips. We have Rebecca House Schultz and we have Andrew Hogue, who are experts in all things legal as it relates to, especially to agriculture. Um, and we have an excellent partnership with them, and they do this just so that we can bring as much important critical information to our members as possible. And of course, the next year's updates, what's coming down the pipe, is always important as we're updating our policies and considering the financial impacts of some of the new laws and things that are coming together. So with that, I'm going to turn it over to Rebecca and Andrew and let them do a deeper dive into their introductions, and then we can get started on our topic.
Well, thank you, Hannah, and Maribel for the opportunity to represent your membership today and speak with your membership about everything that's going on. Andrew and I have a lot to cover, but we'll do kind of a broad brushstrokes view of some important legislation that came down, some trends and hot topics, and then finally a quick legal update on some big cases that came down this year. We'll try to keep an eye on the Q&A, but we can also follow up afterwards if you want to touch base on questions. We'll share our email addresses at the end. We're happy to chat with you, or Hannah and Maribel can send some questions our way. And with that, there's our phone numbers and our email addresses. They're also available on our website. With that, I think Andrew's going to jump into our first piece of new update here. But just in 2025, a big view of what happened behind me at the California legislature here. 2025 was the first year of a 2-year legislative session. There were over 2,000 bills that were introduced. Just under 917 were sent to the governor's desk. He signed the vast majority of them, about 86%, slightly below his average veto rate over the last 10 years. It was, I guess, Andrew, what are your thoughts? A little bit slower of a year than we typically would see in L&E. That's probably because it's the first of a 2-year legislative session. Next year, we expect things to pick up. Certainly, for every action, there's a reaction. So with some of the things going on, especially in the H2A space at the federal level, we expect to see in some of our bluer states like California, legislators looking to make a more employee-friendly reaction to that. So as always, in employment law, more to come. But with that, I'll turn it over to my colleague, Andrew, and we'll jump into it.
Thank you so much, Rebecca. And folks, I'm really pleased to be here with you. I know some of you probably wondering, like we do actually say it was kind of a slow cycle of the 1 of 2 years. That being said, it's 2,400 bills, right? 2,400, and that's slow-ish for California. Nearly 1,000, or over 900 anyway, were passed. So there's a lot going on here, right? I mean, California has a supermajority in both houses of the state legislature, and the gubernatorial office is the same party. So a lot gets through, right? There's not a lot to hold up legislation. So I'm very glad that y'all are with us here so we can have a frank conversation about how some of these things might affect you all and your organizations here as we get into 2026. So first up, minimum wage. And if you think we talk about this annually, you are absolutely correct, right? We talk about this at least annually for a couple of reasons. Number one, because a few years ago, the state codified a mechanism whereby minimum wage will increase every year because it's pegged to consumer price index, or 3.5%, whichever is higher. So minimum wage just goes up. The theory, I suppose, to be to keep up with the cost of living increases, generally speaking, with inflation, et cetera. But in any event, for an employer, if you are paying at or close to the minimum wage, this is something to keep an eye on and to make plans for, right? Because annually, it will go up. Now, it's not just minimum wage in a nutshell, right? Minimum wage is one particular issue, but there are a number of things that are associated with minimum wage increases. And these are the sub-bullets here. So if you have exempt employees, if you classify certain employees as exempt, the minimum salary for those employees increases when minimum wage increases because it's a derivative multiplier of minimum wage. So it behooves all of us to go back and look and see as we end out 2025 and we come upon 2026, whom do we classify as exempt, if anyone, and do they meet the new annual salary threshold, right? And you see it goes up, what, $1,300 and change, $1,600 and change, some of that ilk, so 70,304. The other aspects of this are inside sales folks. If you have folks specifically classified as inside sales, their rates will go up as well. Tool rate slightly increases. And also, and I think this is the next slide, Rebecca, be very cognizant of, and I'm sure most of you are, but be very cognizant of the fact that what we just talked about is state minimum wage. We have, look at this, this is gross, this is massive, right, in terms of local minimum wages. So one thing is important, definitely know whether or not we're paying state minimum wage, know whether or not we're in a locality that requires a higher minimum wage. One good thing, I suppose, for everyone is that the derivative issues, such as the minimum salary threshold for exempt, relies on the state increase, not the local rates. So the local rates affect minimum wage in those localities, but they don't have the derivative results. And then, of course, we've got some asterisks on here, et cetera, for very industry-specific companies. So we've got different minimum wages for different localities for hotels, concessionaires, things of that nature. But it's just a reminder as we get towards the end of the year, let's make sure we've got minimum wage thresholds met, and let's make sure if we have exempt folks that we have those thresholds met as well.
There was a good question in the Q&A, Andrew, about are we focused on ag specific wage orders here in the presentation today? Certainly we're focused on ag and how it will impact ag. You'll see one of the bullet points here was a piece of legislation that passed last year impacting fast food employees and kind of creating a separate framework for how minimum wages would be set for fast food employees. That's frankly one of the concerns that we have moving into the future is, well, with California looking at specific industries, we know the legislature hasn't shied away from looking at ag specifically with like the card check bill, creating the ALRB. Historically, there has been a big interest in the legislature in taking a look at ag. Is that something to look at prospectively moving forward, especially with the H2A adverse effect wage rate changes that came down this year? It's possible. So certainly it feels like a lot of these cities are not hubs of agricultural activity. Certainly Sonoma County is for our wine grape growers. And we see that certainly impacting growers and farm labor contractors operating in those counties. But this is a trend and something certainly that we see potentially impacting ag in the future. There was also an ag specific minimum wage or a threat of an ag specific local minimum wage threat in Ventura County area last year that thankfully didn't go through, but we're seeing this as a concerning trend moving forward. So past legislation, I think Andrew, you were going to talk about AB 2499.
Yeah, absolutely, absolutely. Thank you, Rebecca. So this is past legislation, right? So this legislation will take effect as we come to the new year. So new requirements on employers on how you handle employees who are considered crime victims. So if you've got a pen, if you've got a pencil, jot this down because this will impact everyone because there are new disclosure requirements for employees, and there's 4 different time periods that are affected. One is upon hire. So that's going to be all our folks, right? If you have a checklist for new hire documents, this should be included annually. So January 1 or whenever you have that first meeting when folks are coming back to work. Upon request, if an individual requests information about crime victims' rights, or when applicable. So when you as an employer catch wind of the fact that somebody is requesting a leave of absence because they might possibly be considered a crime victim. Now, this legislation increases what a crime victim is. So it broadens it pretty substantially. It's not just those who are directly subject to domestic violence, sexual assault, stalking, but also those who experience other crimes or abuse, including bodily injury to themselves or others, threat of injury or death, and death of family members. So look, this one is difficult, folks, because I say, like, we don't necessarily really think about this on a daily basis, thank goodness, but we need to make sure that our HR managers or our supervisors, et cetera, are apprised of these requirements, that there are protections for leaves of absence for individuals who are considered crime victims, and there are disclosure requirements. So that's the first thing. I urge folks to take a note, make sure you go back and you revisit your new hire paperwork, et cetera, and include this. Now, the Civil Rights Division will have a notice coming out. It has a notice coming out. It's out. Sorry, it's a page and a half. And you can download that one and just you're good to go. So upon hire, you could just include that in your personnel files in what you give to employees. You can also it's required to do it on an annual basis as well. So just to be cognizant of this one. Hopefully it doesn't apply to a lot of employers on a regular basis, but where it does, we need to make sure that we're cognizant of the protections.
Yeah, and now is a great time to, like Angie said, take a look at your onboarding, but your employee handbook as well. There's always a good time, at least annually, to like take a look at that, make sure it's updated. This is another one that I think a lot of ag employers, and I had someone say they're in the manufacturing industry, for you guys as well. I think this is certainly interesting. AB 692, no stay or pay. So employers sometimes use these contracts, which the legislature is referring to as traps, which obligated workers to repay for costs like training, tuition, other fees. If the worker left the job before a specified period of time, it was intended as, hey, if we're going to invest in you as a company, we'd like you to stay so that we can reap some of the rewards of the training we as a company have gone ahead and paid for you to receive. The idea is there's a lot of strings now attached for employers to navigate using those. There are exemptions, which I will jump into, for tuition programs that are transferable. So if it's a program that the employee and training that the employee takes with them, a certification that the employee takes with them, then there are exemptions. So transferable, can take it to any job. That's exempted from this TRAP exemption. They must have a separate written agreement. It can't be a condition of employment. The agreement must specify a specific repayment amount, which cannot exceed the employer cost of that training or certification that the employee received. And then there has to be a prorated payment amount if the employment ends, and no accelerated payment schedule. So the long and the short of it, and the takeaway for you all, is if you have these programs in place, and I know a lot of employers that do this, if, hey, we're going to invest in you, we want to be able to get some of that money back if you leave us quickly thereafter. Make sure you have counsel taking a look at it and making sure that these requirements are in place in your template if you do this quite a bit. And if it's something that comes up for you in the future, just let this be a tickler in the back of your mind that, hey, let's have that reviewed by counsel and make sure we have a separate agreement in place for the employee to review and memorialize our conversation about that type of an agreement.
And no termination, right, Rebecca, to avoid the final payment there.
Exactly. Yeah.
So I should probably go without saying, but
yeah.
We have seen that previously where there is a sort of an at-will employee and the employer terminates, and right, we want to avoid terminating to avoid those payment requests back to the employee.
Absolutely, good point, Andrew. And then this one is a piece of legislation that came out actually last year that you might have heard about. A lot of employers, in response to the ag card check bill, for example, were doing preemptive captive audience meetings or informational sessions with employees about what card check meant for the company, what unionization would mean for the company, etc. This law came out partially in response to that. The idea that we can't essentially have captive audience meetings anymore, establish new written notice requirements, advising workers about their rights under the law. I'm sorry. I think I got this mixed up with a different piece of legislation. That piece of legislation that I was referring to is on hold. Cal Chamber did a lot of litigation and kind of took that up. So that legislation is on hold. This, I think, is in response to that, just new notice requirements for workers specifically. And this one that we've highlighted is certainly a hot topic for agricultural employers, immigration inspections. That was already in place if you were subject to an I-9 audit, that you go ahead and provide notice to your workforce within a very short period of time. There's a template that California has put out on what that notice should include on the notice. But it essentially more know your rights for workers. We've seen the state come out a lot with these. There was one a couple of years ago for specifically H-2A workers. But this template is to be coming out in January. So more to come once we see what the template is, but unfortunately more paperwork for your HR teams to navigate here. We'll also want to keep a close eye on the template that it comports with the law. That was an issue that we saw with the supplemental H-2A notice, that it didn't actually track. And there were some conflicts between the federal and state obligations there. So more to come. We'll be on the lookout for a template to come out in January. And then Andrew, you're going to talk about PAGA reform.
Yeah, thanks, Rebecca. Hopefully there aren't too many of you who have had to go through a Private Attorney General Act lawsuit, but I imagine there are a handful, because this was a very lucrative statute for plaintiffs' lawyers. As more and more of us have mandatory arbitration agreements with our employees that include class action waivers, plaintiffs' lawyers, plaintiffs' firms, lawyers who represent employees, came up with the idea of deputizing individuals to become private attorney generals, to basically collectivize, more often than not, wage and hour lawsuits. For those of you who are active in the Chamber of Commerce, et cetera, and other organizations, or maybe you've had a PAGA lawsuit, et cetera, you can know how just devastating these can be and how extremely expensive they can be. So because of that, because these were settling for 6, 7, even 8 figures for larger employers, California Chamber of Commerce and the business community generally across many industries wanted to reform PAGA. And it's essentially the threat was to have a proposition that would get rid of PAGA. And sort of the compromise that resulted with our current governor, perhaps running for president, et cetera, was, well, we can reform PAGA. So instead of having a proposition where we would get rid of it, he sort of looks a little more business friendly with a reform compromise. So this is an extremely valuable opportunity for employers across the board. PAGA penalties are ridiculously expensive because they're based on pay periods for employee headcount. Again, they're collectivized, similar but different than class actions or collective actions. But the PAGA reform allows, if you take all reasonable steps to ensure that you're complying with the law in a timely basis, an 85% automatic, so to speak, reduction in the value of those statutory penalties. But can you imagine if you don't take all reasonable steps and get hit with a PAGA letter to the Labor Workforce Development Agency and a PAGA lawsuit, right? You'll be paying full value for the statutory penalties, $100, $200, et cetera, and others for other specific statutory sections for every employee, for every pay period, over the PAGA statute of limitations. It adds up massively. You can get up to an 85% reduction if you prophylactically engage in, I say essentially an audit process, because that's the biggest part of taking all reasonable steps to make sure that your practices and policies comply with California wage and hour law. After you get a letter, you have a short window of a couple months to get a somewhat smaller discount on the statutory penalties. So you'll lose 15% of the discount, but still extremely substantial. So here's the takeaway really for this. Consider whether or not you want to take a prophylactic PAGA audit and you want to take all reasonable steps to evaluate your wage and hour practices. This includes things like a review of the employee handbook, making sure that you have an arbitration agreement, confirming. Unfortunately, we see this one fall. This is the third bullet here is sort of a practitioner born by experience, that we not only have arbitration agreements, but we have somebody tracking that every employee, including your HR folks, are signing the arbitration agreements. Too often we see lawsuits come through. We thought we had a policy that there were mandatory arbitration agreements, and then we find a slew of employees who have not signed the arbitration agreement. We review payroll administration rules and instructions. Bonus and commission plans can be absolutely huge in this regard because they affect other things like regular rate for meal period violations, rest period violations, overtime, etc. And then especially, and we'll touch upon this again once we get to our case law, our standalone policies that deal with wage and hour matters. So we definitely want to make sure that not only our handbook is compliant and updated, but that our standalone policies, if we have any, including our arbitration agreement, including any policies on meal breaks, rest breaks, things of that nature, are compliant and don't essentially interfere with our ability to enforce our arbitration agreement. At the end of the day, the notation on this one is, should we consider a PAGA audit right now prophylactically? That's the big one here. And we can walk you through that. There are some other things that might result from the PAGA audit, including, and these are good steps anyway, even outside of the audit. So not only are you getting the 85% reduction if you ever face a PAGA lawsuit in the statutory penalties, but hopefully you'll also have more compliant practices through these mechanisms. So training on wage and hour matters. I think especially for sort of supervisors, managers, et cetera, right? Because those are sort of our boots on the ground who hopefully are enforcing compliant practices. It can be live, it can be web-based. There's various management tools that we can utilize for these types of trainings. I tend to prefer them when they're in person for a lot of workforces, but it just depends on sort of time where people are, et cetera. Refresher courses throughout the year. When a court is looking at whether or not an employer is taking all reasonable steps to comply with wage and hour law, it matters whether or not you train people. It matters whether or not you have policies. It matters whether or not you're reminding people to make sure they take compliant meal and rest breaks, et cetera. And then the bottom bullet point here, AI is coming. AI is here. There will be a lot of options for AI training modules, et cetera. And folks, it's scary. It's above my head, frankly, in a lot of ways. But we're already seeing legislation that affects whether the impact of AI in the workforce and whether or not employers are responsible for things like discriminatory hiring practices precipitated by artificial intelligence. But in terms of training, it is available and it's out there, so something to consider.
I have a couple questions here, Andrew, about arbitration agreements specifically, always a hot topic. We have an arbitration agreement. Aside from having it in our team member handbook, should we have employees sign a standalone arbitration agreement annually?
Got it. It's a great question. And I don't want to say that the question is so good that it might be specific, because there are some generalities, but it will be something that you do want to discuss specifically with your workforce, with the counsel whom you work with. Generally speaking, in California, we no longer recommend, and there is a chance that a court would strike down an arbitration agreement that's at the end of an employee handbook. That's the way we rolled them out a number of years ago. I mean, wink, wink, attorney-client privilege. It's because people would just flip through the end and sign and move on, and we'd be done. We have the agreement. Courts have really pushed back on that. And so it should be a standalone document. Whether or not you should roll out a new one annually, that's going to depend on your workforce. There are a lot of workforces that we see for various reasons that they get a lot of pushback with signing of arbitration agreements. So they might want to consider whether or not it's necessary, whether or not there's been new statute or new case law that suggests that you really do need to update the arbitration agreement. All things being equal, if things have not changed and we believe legally you can still enforce your arbitration agreement, I don't see any reason to pick that scab. Let it be. That being said, there are often annual changes that can make your arbitration agreement have a better chance of enforcement. And so it's an annual consideration, at least an annual consideration for sure. I don't know many clients who are rolling out new ones annually. There are some certainly, but it's more of a case by case. Do we believe that we can still enforce the prior one? But it's certainly something to visit and to make sure that you have compliance, that you're keeping those in personnel files, et cetera. Yeah, Rebecca.
Just to chime in on that, Andrew, I agree wholeheartedly. If you do have a seasonal workforce where you are laying folks off every season, for those employers, I generally encourage, let's go ahead with our new onboarding to do an arbitration rollout again. That's a great time to roll out a new employee handbook at the same time and just kind of fine tune everything and make sure we're up to date. But there is that argument that if there's a gap in employment, that we need a new arbitration agreement. So include it then. If you are an H-2A employer, make sure that the arbitration agreement and the fact that you have an arbitration agreement or an alternative dispute resolution is included in your ETA 790. There was a case that came out on that we were involved in litigation of, but it needs to be disclosed to DOL that you are doing that. There was one more question on arbitration agreements while we are here. I guess there's similar that are in the same boat here. So let's lump them into one. What if we can't get an employee to sign an arbitration agreement? What if they have been a long-standing employee of ours and we've rolled it out and they're refusing to sign them? What do you think, Andrew?
It's a great question. It's a great question. I tell folks, if you're going to have a policy of arbitration agreements, consider in advance what you will do when certain people refuse to sign. And I think the vast majority of folks take the position now in California that we want the same policy applicable to all of our employees. So if we're going to roll it out, it's going to be a condition of employment. It's going to be mandatory, and everyone needs to sign. Look, that being said, I realize that's easy for a lawyer to say, in an office building versus, the prospect of you potentially losing a valued team member who's been with you for a long time. So are there employers who do have exceptions for like one or two people? Sure, there certainly are. But I mean, at the end of the day, and we can talk about how to roll out arbitration agreements and how to converse with employees about them, et cetera. Look, you go to the dentist's office, you're signing an arbitration agreement. You go to any medical healthcare provider, you're signing an arbitration agreement. You go to most employers, you're signing an arbitration agreement. It's a quicker experience more often than not than litigation. It's cheaper more often than not for the employer. There's quicker remedies for it's not like you're trying to pull a fast one on individuals. I mean, you are trying to get a class action waiver, but frankly, if you only have one or two or a handful of employees who are not signing them, you already have the value of a class action waiver because the vast majority of your workforce has waived their right to participate in the class. So it becomes less and less valuable to make sure that everyone signs, but it's a case by case situation. I got to say, as an employer, I want across the board policies that are applicable to everyone. I appreciate a long-standing, long-tenured employee who's very valuable to the organization, but everyone signs, right?
Yeah.
I mean, I drop off my kid to school and, he's in second grade and they have the rules for the entire class and everyone abides by them, right? And if there's a new rule that pops up, everyone agrees. If not, you're not there. I don't mean to make that sound harsh. There are softer ways to kind of roll that out, but I really do believe that having uniformity in your policies can be helpful to everyone.
Yeah, it's a real labor relations issue. I agree with you wholeheartedly, Andrew. It needs to be a conversation with your HR team and management on, okay, what is our level of risk tolerance? And I think the area where it can get really tricky is the area Andrew identified. You have a key supervisor or foreman who just won't sign the darn thing. And we really like this one, but what are we going to do if the one that we aren't crazy about refuses to sign it? We've got to treat everybody the same and come up with a game plan on how we are going to treat folks that refuse to sign it. And rolling these out is really an art, and you need to be working with your labor relations folks and attorneys on what makes sense for you as a company. I like to pair them with a handbook rollout so that it's not all just arbitration, and hey, we're doing orientation, let's sit down and go through some new things and focus on, good things that the company is doing for the workforce as well, and use it as a labor relations catch-up moment for the team, and then explain what arbitration means to the workforce as well. Look, it can be helpful for employees too. It's generally a lot faster method to get to adjudication of their case than, going through Superior Court would. It's really expensive for the employer, and the employer is paying for all of the cost of administering the arbitration, which in and of itself can be upwards of 6 figures. So there's good things for both sides to talk about in arbitration. Certainly, employers have been focused on rolling them out given where we are in the class action landscape, but they're beneficial tools for employees as well. And so I think rolling them out in a way that explains the good things to employees in a fair and balanced way. There's a case that we're going to get to a little bit later on in the presentation about the rollout of these arbitration agreements, but it has to be fair, has to be clear to employees what they're waiving and what they're giving up. And I think even having a PowerPoint that you use in an outline to employees, or talking points if you're doing it out in the field, explaining what the agreement is and what employees are signing is very helpful, because courts are really taking a hard look at these, and that's certainly the trend. Okay, let's maybe, in the interest of time, move on here from arbitration, but it's certainly a hot topic, and obviously something a lot of employers are dealing with. Andrew, I didn't mean to cut you off. Did you have anything to talk about on PAGA reform or audit?
No, thank you, Rebecca. And
Okay.
To your point, we'll revisit it in the case law, and in any event, we'll come back to PAGA and then arbitration agreements.
Absolutely. So just quickly, we wanted to touch on immigration and where things stand. I just had a call right before we hopped on here about the One Big Beautiful Bill Act and its implications on overtime. But one thing that I think has certainly been covered in the news, but important to point out, the act also gave a big boost to ICE's annual budget. The budget is tripling over the next 10 years, alongside a huge hiring uptick. 10,000 new ICE employees over the next 5 years, which effectively doubles their current workforce. We expect this to lead to increased ICE activity. And so what that means for employers at this point, we can plan as best we can for a raid or an I-9 audit, and knowing that ICE is likely increasing its activity. So great time, just like I feel like, unfortunately, we've given a lot more to your to-do list today. Take a look at your handbook, take a look at your arbitration agreement. Also, take a look at how you as a workforce are handling or plan to handle an SOP for immigration activity, whether that's an I-9 audit or a raid on your facility. So wanted to highlight this statute that's been around for some time, the Immigrant Worker Protection statute, AB 450. This is something that actually requires employers in the state of California to not give permission for ICE to enter the workforce. They have to have a valid judicial warrant. And if you have questions about what a valid judicial warrant looks like, we'd be happy to give you a sample or show you that. But really, it's going to have a district court name at the top. It's going to be signed by a judge, and it's going to identify the scope of where the officers can go ahead and search, whether that's individuals or a specific area. If there is an I-9 audit or inspection, there's a requirement under the California law to provide employees notice of that inspection. There's a template on the state's website of that notice and what it should look like, but you should certainly be working with counsel to update that notice if that happens to you, and certainly come up with messaging from a labor relations perspective of what communication would be accompanying that. No voluntary re-verification. So employers cannot require employees to re-verify employment eligibility unless they're required to do so by federal law. Sometimes there's confusion just within the HR team and maybe a little bit more training needed on, oh, the driver's license expired. Do we need to re-verify? No, we don't need to re-verify those types of documents. So making sure that your team is up to speed on what types of documents actually require re-verification for work authorization in the US and what don't. Obviously, there's steep penalties for not complying from an I-9 perspective. This comes with penalties for not complying with the judicial warrant requirement, the employee notice requirement of an I-9 inspection, etc., for violating this statute. So certainly something to be aware of. This is more just updates from an immigration perspective. For I-9 practices, there's steep penalties up to $28,619 for unauthorized workers and just little ticky-tacky paperwork violations, steep penalties associated with those as well. We have seen a slight uptick in I-9 audits with ICE staffing up and a focus on immigration activity. We expect that to continue. So we have an employer's rapid response team. You know, my clients know to certainly get in touch with me and text me, email me, let's talk about it. FP also has a 24/7 emergency hotline for employers that are in an active ICE raid. So this is staffed 24/7 by a member, an attorney from our immigration team. So use it in the event of an active ICE raid, have that number handy and ready to go. And then we also have different toolkits available for purchase. So reach out to us, to Andrew or I, if you have questions about ICE immigration activity or navigating an I-9 audit, or maybe even doing a preemptive internal I-9 audit to get out ahead of any issues that may exist for you. So with that, we'll transition into our legal update and some cases that came down this year that we wanted folks to be aware of and alerted to. So Andrew, I'll let you take it away on this one.
Awesome. Thank you, Rebecca. Yeah, so we can go to the next slide, I think, on this one, Rebecca. And look, you probably, folks every year probably have a Cal Chamber of Commerce versus Bonta opinion that comes out, but that's just because the Chamber of Commerce is, will challenge certain employment law bills that come out. And that's what happened here. There was a challenge from the California Chamber of Commerce to Senate Bill 399. And this Rebecca mentioned earlier about the captive audience, right? And sort of that prophylactic, like, okay, if we see where things are going, maybe we do schedule a meeting with employees where we discuss, unionization, et cetera, et cetera. This legislation, Senate Bill 399. So let me be clear. First of all, there's a preliminary injunction against it. So it's not enforceable currently. But the state of that could change quickly. But when we talk about Senate Bill 399, while it is codified in the California Labor Code, it's not enforceable. So there's a preliminary injunction against enforcement, but the Ninth Circuit is reviewing that, and who knows what the Ninth Circuit will say. It may not be good for employers. What Senate Bill 399 did was essentially say employers cannot require employees to attend these captive audience meetings where political matters or religious matters are discussed. Right? We just got over Thanksgiving. It's sort of like with your family, right? The things you don't talk about, politics, money, religion, sex, etc. That's essentially what this legislation was, right? That employers cannot require employees to attend meetings where political matters are discussed. Now, political matters, we put that in quotations in the first bullet point there because it's a loaded term. It's a very broad term in the statute. Essentially, what I think it's getting at ultimately is that last part of it, labor union organizing, right? So employers cannot hold a captive audience where they discuss labor union organizing in front of employees who are required to participate, required to attend the meeting. The Chamber of Commerce filed suit and said, hey, look, this is really governed by federal law. The National Labor Relations Act and the National Labor Relations Board has jurisdiction, et cetera. This is not an individual state-by-state issue. This is very much a federal issue in terms of what speech is protected, what speech is prohibited when we're dealing with things like union organizing. So there's a preliminary injunction right now in the Ninth Circuit. Stay tuned. We don't know how that will go, but to some degree, the writing's on the wall, right? That the legislature does want to pass something of this ilk. So make sure that you have you're in touch with us and that you receive our updates, etc. Because when the Ninth Circuit does issue its opinion on the preliminary injunction, it can make it a permanent injunction, or it can essentially deny it, and then Senate Bill 399 and that labor code statutory section would be enforceable once again. And Rebecca, I don't know if you have anything to add on that. You hit the captive audience earlier.
Yeah, I think it's important to know that you still can have those. There was some concern that, okay, what does this mean? We need to be communicating with our workforce, especially our ag workforce, about card check. UFW is sending a lot of messaging out that is misleading about folks will probably remember the farm worker bonuses that came out for the essential worker activity during COVID. UFW was one of the foundation was one of the organizations that could go ahead and administer that benefit. A lot of times what we found out through declaration drives and campaigns was that UFW was presenting a card check signature and then also a signature for getting your farm worker emergency COVID benefit at the same time, and kind of misleading about what folks were signing. So a lot of messaging needed to be done and arming the workforce with information about the power of their signature and what that meant. But you can still go ahead and have those meetings is the long and the short of it at this point, which is good news. And glad that Cal Chamber took that on. Speaking of power of signature, I was just going through the Q&A in the chat while Andrew was speaking there. There was a person that talked about rolling out arbitration agreements, and maybe the first year a little bit of the messaging was off and there was some hesitation in the workforce about signing. And then in the next year, the company had kind of refined their messaging and made sure that they were spending a lot of time educating the workforce about what the arbitration agreement meant, and it went over a lot better. I think that's a great example. There's a lot of power in a petition to compel arbitration also from a legal perspective, where we compare that with all the information the employer gave about the arbitration agreement, maybe a talking point sample of all the information we gave the employee, a PowerPoint presentation of what was actually discussed during that meeting. It can be really helpful in the success of those motions to compel arbitration and enforcing your arbitration agreement too. So it's a twofold benefit, helps us on the legal side in moving to enforce your arbitration agreement, and then also shows your transparency and level of communication with your workforce. So great point there. I wanted to share with the audience. Okay, jumping into another case here. I am not going to venture to try to pronounce this. Andrew, I don't know if you can, but we'll just call it the Bakersfield Recovery Services case. The long and the short of it here is that this was an employee who entered a substance abuse treatment center. He took some leave after his long-term partner passed away. While he was out on leave, there were some off-duty interactions between him and a coworker, and unsolicited sexually explicit messages. So what a lot of employers do in this scenario, and it sounds like what this defendant did here in this scenario, was say, hey, this was off work, you were on leave at the time, doesn't involve us, we don't see it as impacting your employment, file that away as interpersonal relationship that doesn't have to do with workplace on-site activity. Plaintiff then filed suit under the FEHA about that, saying it impacted his ability to work. The court originally said, yeah, we're gonna say this was off work activity. We're gonna dismiss the case at the trial court level. Plaintiff appealed, saying, no, even though this happened off-site and not on campus at work, it impacted my ability to do my job such that it created an abusive or hostile work environment, which is a valid claim under the FEHA. So what the court did here was say, even though this happened off-site, it sufficiently, or the plaintiff sufficiently pled that it changed his work activity such that the offsite conduct impacted his working environment to such that his claims could survive that initial motion to dismiss. We've seen a couple of these cases come down. There was one last year too. The moral of the story here is that even if it happens off-site, an employer cannot immediately out of hand, say, well, that's an interpersonal off-site issue. We're not going to jump into that. And we see that happen a lot in production facilities, in crews where folks become friends, folks are sometimes family members, and there's a lot of overlap there of stuff that happens on Facebook, on WhatsApp, on whatever's the latest social media craze that I'm not up to speed on. But that stuff can filter into the workplace and unfortunately become something that HR has to handle because of how courts are interpreting these broad brushstrokes FEHA type cases now. So certainly HR should take a proactive approach. Even if the employee is complaining about something that happens off-site, that doesn't mean our inquiry is ended and our investigation is ended. We need to take a look at it because of these cases that are coming down now. Andrew, did you have anything to add on this one? Okay.
I think you're spot on though, right, Rebecca? It's just such a huge cautionary note that here, folks, the employer, Bakersfield Recovery Services, was not responsible for the underlying conduct of the bad actor, of the employee off-site. But the court said the employer is liable potentially for its response to the employee's concern when the employee comes back to work. Right. So we just have to make sure that HR and managers, et cetera, are taking these complaints seriously and not turning a blind eye, even if the employer is not liable for the underlying conduct because it might have taken place offsite, et cetera. Yeah. Scary in some ways. All right, folks, trucking along. Herdman versus Charter Communications, LLC. Another PAGA matter. Another PAGA matter. Okay, so we talked about PAGA reform. And I think we're starting to see cases like Herdman because of the PAGA reform. Okay, so primarily because I can't see you all, but like think to yourself, have you taken all reasonable steps to get a PAGA reduction of 85%? Right? Yes or no? Right? A lot of thought was around the idea that we would stop seeing PAGA litigation because if employers took these reasonable steps, the 15% that employees could get by filing PAGA actions of the statutory penalty would not be as lucrative enough. I don't think we've seen that statistically, and the numbers bear out. And instead, we're starting to see cases like this, where we've got sort of niche areas. So Herdman was classified as exempt outside sales, an exempt outside salesperson. And the issue here was whether or not Charter Communications calculated his paid sick leave correctly. I think the note here, the takeaway that I want here for folks is consider whether or not you have employees classified as exempt. Right? Do you have salaried exempt folks in your organization? If so, HR or someone should be able to identify what exemption you're classifying each of those employees under. Are those individuals administratively exempt? Are they professionally exempt? Are they executively exempt? Are they outside sales exempt? Are they inside sales exempt, etc.? Because all the exemptions are not created equal. And this is where this one comes up. The individual said, hey, look, the paid sick leave for an exempt outside salesperson is calculated incorrectly. And so I think this one is sort of the cautionary note or the cautionary tale that, again, not all exemptions are created equally. So understand and appreciate what exempt employees are exempt from, right? Are they exempt from overtime? Are they exempt from paid sick leave? Are they exempt from meal breaks? Are they exempt from rest breaks? All exemptions are not created equally. At the end of the day, this one, again, is sort of niche because many of you might not have folks classified as exempt outside sales, although quite a few of you might. But again, just understand the exemptions are different. Appreciate and document. I like a spreadsheet. Who's classified as exempt, what exemption, and what are the payroll implications? Rebecca, I don't know if you have anything else you want to touch upon on Herdman.
No, I think it's another good bullet point to remember that the audit is very helpful. So these little ticky-tacky issues sometimes come to light in an audit. There's so many various pay rates in ag and in construction, for example, or in manufacturing. Audits are very helpful in confirming that your payroll system is talking to your timekeeping system in an appropriate way and capturing the regular rate of pay correctly and doing all the math that technology is designed to do for us in an appropriate way. So another plug for going ahead and doing that PAGA audit, especially if you already are not in the midst of litigation. If you are, talk to your attorney first, but if you are not, probably a good idea to go ahead and do that now.
All right, folks. So continuing in that vein, right, Rebecca, we've got another case on arbitration agreements. So to y'all's points about should we roll these out annually? Do we consider rolling these out or requiring these for the folks who haven't signed? Do we have them as part of a handbook or other documents, etc.? This case is prescient for a number of those questions. So Silva versus Cross Country Healthcare, Inc. Silva had an arbitration agreement. And Silva had what we'll just say or argue or point out is an enforceable arbitration agreement. Yet, Silva also had an employment agreement. Now, employment agreements are not inherently bad, okay? But we need to understand and appreciate that if the arbitration agreement says one thing and the employment agreement says something slightly different, there might be legal implications on how a court evaluates an important term of employment like arbitration. So here what we had was an employment agreement that essentially had some aspects that would violate our rules that govern whether or not arbitration agreements are enforceable. And the employment agreement said that it superseded all prior and contemporaneous agreements. Well, what does that mean? If the arbitration agreement is signed first and the employment agreement is signed second, the employment agreement voids the arbitration agreement. And I think, folks, team, we're going to see more and more of this type of argument with creative plaintiffs lawyers. It's a great argument. And I think I see it quite a bit where an entity, an employer might have borrowed employment policies or a borrowed template for something like an employment agreement. And then we have sort of this pseudo legal language about what document takes precedence, et cetera. When we roll out arbitration agreements, this case is the cautionary note for we should not review and update just the arbitration agreement, but we should review and update an offer letter, an employment agreement, standalone policies that might mention arbitration, the terms of arbitration, or other terms of employment, because we want that arbitration agreement to be enforceable. And back in the day, folks would just look at the arbitration agreement as to whether or not it met certain factors and certain standards in California and whether or not it was unconscionable. And now folks are starting to look at other documents and saying, whoa, we have sort of an integrated larger contract, and there might be some language in these other documents that supersedes or takes precedence over the arbitration agreement. So again, just a cautionary note, right? Even if we have a policy that we roll out a new arbitration agreement annually, let's make sure we don't have other documents that interplay with that arbitration agreement that might make it unenforceable.
Okay, more on arbitration. This is another case where plaintiff's lawyer challenged the arbitration agreement. We're seeing that a lot, as Andrew mentioned, where plaintiff's lawyer will at least take a shot at challenging the arbitration agreement. This case highlights the importance of the rollout of the agreement. And I think what really moved the needle here was this one fact that we'll highlight. An arbitration agreement was rolled out with 31 pages of onboarding paperwork. The employee specifically told the HR manager, I don't understand the arbitration agreement. I don't want to sign it. The HR manager said, quote, it's to help us resolve disputes without lawyers, which isn't necessarily the case, right? Like even if you're in arbitration, plaintiff's probably going to have a lawyer, employer's definitely going to have a lawyer helping them navigate that situation. And I think when the court was reviewing this this decision, it really focused on that fact and said, hey, you can't give information that's false to an employee and then expect to be able to enforce that agreement. So the court actually invalidated that arbitration agreement and said that was not fair. They weren't going to go ahead and enforce that as to this employee. So this obviously stresses the importance of how agreements should be rolled out to employees, the level of training that your HR staff needs to have on the arbitration agreement. And I think pairing the standalone arbitration agreement with talking points and maybe a PowerPoint presentation. You hate to start adding more documents for the case that Andrew just went over that maybe don't match up and arguing about it, but having evidence of how the agreement was rolled out and explanation, I think, is very important as these challenges continue to come down the pipeline and become more popular. Okay, so this is a case that's been going on for some time. I think our case law update last year talked about Can't Be Home Depot, and that hopefully we would have more information. This is about a wage and hour issue and rounding. There's a seminal case that we've been citing for years and years and years called See's Candy, which stands for the proposition that if rounding is neutral, meaning it doesn't benefit one, the employee or the employer, then we can go ahead with rounding. This case is really looking at, okay, but what if the trend is detrimental to the employee? Is that fair, even if the policy on its face is neutral? So really challenging rounding at all. There was a case that came down involving Starbucks a couple of years ago, talking about capturing, and one of the concurring opinions talks about capturing fractions of a second. I think that gives us a little bit of a preview into how the court is looking at this issue. I don't think that they're going to be big fans of rounding. If you have a rounding policy in place right now, even if you're using paper timekeeping, which I know a lot of employers out in the field are still doing, we like to be as specific as possible. Unfortunately, that's going to make your payroll team want to pull out its hair, but the more time can look messy and be 6:03 in the morning versus everyone is perfectly appearing at 6 o'clock in the morning, the better. Because these challenges are coming down, we expect this case will put a ding in the rounding and potentially uproot the See's Candy case that we've all been relying on. So if you are using rounding, if your software platform has a rounding rule in it already, now is the time to take a look at that, talk to your counsel, and figure out a way how to move forward prospectively in light of this decision that's going to be coming down.
Yeah, I don't want to tell folks what to do, but don't round.
Yeah.
The court is utilizing language in that, right, Rebecca, that basically says, look, in the 21st century, like and whether or not this is practical or not is another story for you employers, right? And we're cognizant of that. But in the 21st century, it's not overly difficult to capture time to the minute, and so the idea of rounding is sort of looked at even initially with sort of an eye of caution. Like, why would you do that? And I'll say, even when our young son required a nanny and she would write down her time, I would say, Emily, please stop writing like 8:25, right? Like, it's okay if you get here at 8:02, I'll make up for it, but please put 8:02, because I call it idealized time, right? Like every time at 8, every time out of, that's not very realistic, right? Folks are 1, 2, 3, 4, 10 minutes early, late, etc. And courts are basically saying we should capture that. So with our final minute, we're going back to the Private Attorney General Act. And this is a good one for you. Now, there's a sort of a companion-ish case that's not as good, but essentially we have dealt with as lawyers the last handful of years a lot of uncertainty with the Private Attorney General's Act and how employees need to plead them, what exactly a Private Attorney General Act claim is, etc. Because recall our conversation that they're sort of like class or collective actions. I mean, they're not just an individual. They try to argue that they should get penalties on behalf of other putatively aggrieved that have suffered similar or even different wage and hour violations. We were having some success litigating these things on behalf of some of you all in basically bifurcating and saying if we had an arbitration agreement, we could still force the individual private attorney general to arbitrate the individual claims before a court would adjudicate the collective claims on behalf of the rest of the putatively aggrieved. Plaintiffs' lawyers didn't like that. They didn't want to be in arbitration, which I always tell people is an indication that you probably want to be in arbitration, right? That employees and their counsel fight these things tooth and nail. Sort of an indication that we want to be in arbitration. So they started filing them and basically saying, well, we don't have an individual claim. We only have this collective claim. So we want to go straight to court. Right, and we've been fighting over that, and that's essentially what this case deals with. And we're going to get some decisions here in the somewhat near future as to how that all bears out. At the end of the day, I think for you all, now is the time to consider whether or not you want to go through the prophylactic PAGA audit, et cetera, and take all reasonable steps. Because we don't really know how all this is going to play out, but there's a lot of interest involved in it. These are still very lucrative, very expensive to defend. And those PAGA audits are sort of worth their weight in gold if you've done them prophylactically to get that 85% penalty reduction prophylactically. Rebecca, I don't know if you want to touch on Lieber or.
No, we got a couple more questions here.
Yeah.
I know I want to respect everyone's time. So we'll try to wrap it up here as quickly as possible, but we want to try to get to these. Can an arbitration agreement be a condition of employment? There was litigation about that. I think it was Cal Chamber who kind of took that up on behalf of employers as well. Yes, you can have it be a condition of employment. The legislature tried to put a stop to that, but no, you can. You just have to give accurate information. The question was about that last case that I touched on. You have to give information that's accurate about the arbitration agreement in the rollout of that. There's a question about rolling the arbitration agreement out at the same time as the new hire orientation and whether that's okay. Yeah, you can. Most employers do. I think that's fair, and I'm a proponent of that. You just have to give information about both and give folks opportunity to review both. Andrew, do you have any other thoughts on that?
And team, I mean, look, I don't want to upsell it, but it might be worth a 5-minute phone call with your attorney to say, like, here's what we're rolling out, right? Because a lot of these cases are coming out and saying, like, the documents that you put in front of an employee on day one of orientation were too voluminous, and the arbitration agreement was kind of hidden, and folks didn't really know what they were signing. And you go through that effort and you have the arbitration agreements, we want to make sure that they're enforceable. So can you roll them out with other documents? Yeah, in a lot of ways it makes sense because you presumably have a meeting, an orientation, et cetera, where everyone's there. So it's ideal in that regard. But again, courts are just really looking into whether or not you're trying to hide the ball. Whether or not you have someone from HR just saying like, oh, just go ahead and sign it. It's no big deal. It just means we don't have to have lawyers, right? So false information, et cetera. Or again, at the end of a handbook or with a bunch of other documents. But again, attorney-client privilege in this, I always say, hey, look, there's a fine line to walk here. I kind of like it with a few other documents, as long as it's not too voluminous, because I don't think a court's going to come down and say, well, there were 12 total pages and 4 were arbitration, so no one knew what they were signing. But once you start to get into 50, 60, 70 pages and 5, 6, 7, 8 documents, I don't want to defend that. Well, I mean, I will, but that one's more difficult, right? So I think it's just a cognizant, what's the best way to make sure we believe we can enforce this going forward? And again, Rebecca mentioned we want to be cognizant of y'all's time, but we're here for y'all, right? So, shoot us an email, give us a phone call. We can answer anything through Hannah or Maribel as well if you have additional questions we didn't get to. And thank you so much for joining us. It's been an absolute pleasure. And I'm sorry if it's kind of overwhelming. There's a lot, as there is every year in California, but hopefully we've gleaned some good information to help y'all stay compliant.
Yeah, thank you both so much. This was so helpful, so informative, and please anybody on the call, feel free to reach out to either Rebecca or Andrew, or myself or Maribel, and we'll make sure we get you guys connected to get all the information you need. And this was super helpful. Any questions that you have following up when you're thinking about the presentation, just feel free to reach out to us. We're all here to support you guys. So thank you all.
Thank you. Take care, everyone. Happy holidays.
Happy
Thank you,
holidays.
You
everyone.
guys too. Bye-bye.
Bye.